This video, we're going to cover what I refer to as employment cases. It covers a broad range of matters that involve your employment and possible legal matters. I want to stress this, and this is very important. This is an overview of some of these types of matters. I can't encourage you enough that if you have been wrongfully discharged or fired or discriminated against, call me, the Bulldog, and let us guide you through it. We handle a lot of these cases, and we do them very well. First of all, this is very important. If you quit, you're not going to get unemployment. I tell all my clients, don't quit. Let them fire you. This is true. In this economy, a job, even if it drives you miserable, is better than no job at all. So I want you to know that put up with all the crap you got to put up with to keep your job. Don't quit. There's some exceptions to that. If you are being sexually harassed so severely, you're allowed to quit. It's called constructive discharge. Very important. Before you quit, email me, call me. We'll guide you through it in the beginning. Get counsel. By the way, we give free legal advice on this, so you're going to be getting counsel on what to do and not to do for free. Employment at will. Most states have this. Kentucky, Ohio, employment at will. You know what that means? They can fire you because you wore an ugly Christmas sweater. They can fire you just because they don't like you. We have clients call us all the time. I just don't think my manager likes me. Guess what? They can fire you. They just cannot fire you for some protected reasons. And there are some exceptions. Do you have an employment contract? Although most employment contracts say they can fire you with cause, without cause. But if you have a binding employment contract, let's say for a year, they just can't fire you. The terms of that employment contract control. If you have an employment contract, we need to look at it. Unions. I want to tell you right now that unions, strong history in this country. I think only 10% of workers belong to unions, but if you belong to a union, that union steward and representatives has an obligation to fight for you. So go through the union process. In fact, if you're a union worker, you usually have to begin there. The exceptions, I think I have them up here. Discrimination. Have you been discriminated against? And these are some of the federally protected rights that came out of the 1964 Civil Rights Act. You cannot be discriminated against because of your color of your skin, your race, your religious beliefs, your age if you're over 40, your gender, your, I think I mentioned religious beliefs. They can't discriminate against you if you're a snake worshiper or you're Jewish or you're Catholic. So the law protects you from those discriminatory events. Sexual harassment, very important. By the way, these are my favorite employment cases, not because they involve sex, but because they're the best cases. Why are they the best cases? They're one of the few cases that you can get emotional damages from, okay? And there's two types of sexual harassment. One is quid pro quo. If your boss either directly or implies, I'll do a little play acting here. Hey, Missy, you're looking awful good today. You know, if you spent the weekend up at the cabin with me, I'll make it worth your while. Good quid pro quo claim. He can't do that. He cannot directly or imply, have sex with me, do things like that, and you will not get fired, or you're going to get a raise, or something like that. By the way, it works in the inverse. In other words, they can't say, have sex with me, or do something sexual, and I won't fire you. Quid pro quo. By the way, I'm going to go ahead and tell you something about taping, because it's important in these kind of cases. Ohio and Kentucky is a one-party state. If you've got an employer or a supervisor or manager who's doing this type of thing, save the voicemails, save the texts, save the emails, and tape record it. Keep a tape recorder on your desk. Go out and buy a more complicated recorder. You are allowed to record a conversation between you and somebody else without their knowledge. You cannot record a conversation between two other people. That's the difference. In other words, you can't spy and eavesdrop on others, but you can record your conversations with somebody. Hostile environment. It has to be severe and pervasive, and that's what we're talking about, is that if you are at a work environment where they're talking sex, and sex is this and sex is that, and you're getting the sex emails, the sex texts, I mean, it's just a sex-filled place, and you don't like it, and it is creating an environment that you're uncomfortable in, you might have a hostile work environment. I want to stress this. It has to be based on sex. I get a lot of emails and phone calls from people that say, I'm in a hostile work environment. I say, well, what's going on? Well, my boss doesn't like me and makes me go get his coffee. He berates me, makes fun of me. Sorry, it has to be sexual, hostile work environment. And something else about this, which is significant, is if you participate in that, in other words, if you can't like send sexy emails to somebody and then complain they're sending them to you, you have to have clean hands, okay? The other thing that's very important is most work environments, and I'm going to go ahead and tell you this, my own, you have to know your workplace. In my workplace, we're lighthearted. Nobody crosses the boundaries. But I will go ahead and tell you, like at my place of employment, there are some people that can tell a sexual-based joke and everybody laughs and nobody is upset with it. However, if I employ one person and that one person is offended by that, we can't do that. That person, we have to avoid that person hearing a sexually based joke. Cannot hear it. The other thing, the most famous case is Bill Clinton, all right? I use on the radio term willy whacker. That's my term, for the male genitalia. Because you can say that without getting in trouble with the FTC. Bottom line is, Bill Clinton famously, according to Paula Jones, showed his willy whacker to Paula Jones when he was the governor of Arkansas. She sued him. They actually settled the case, and that was the downfall of Bill Clinton. If he was smart, he would have let him get a default judgment against him because he wouldn't have had to testify. That case brought down Bill Clinton. But guess what? This is very, very important. He committed perjury during the deposition, and he also lost his license. But do you know he ended up winning the case? The court ruled that showing his willy whacker, even if he did it one time to Paula Jones, isn't enough. It's almost like you get one free bite at the apple, if it's not too perverse. I guarantee you right now, don't rely upon something like that. One really perverse event might just create a hostile work environment. The law does not protect you from having a jerk from the boss. I have a lot of people, they want to sue their boss because they're a jerk. I got this from Judge Bertelsmann. Judge Bertelsmann, the federal judge in Covington, said this. I quote to clients all the time. I say, Judge Bertelsmann always says, the law does not protect you from having a jerk for a boss. Age discrimination, you have to be over 40. 39 years old and 364 days isn't old enough. We draw the line at 40. And you have to prove that there was an adverse action against you based upon your age. You can't say, I think they did. Let me give you an example. The best age discrimination case is this. You get fired, and it's not an economic thing. You get fired, you're making $50,000 a year. You get fired, and they hire a 20-year-old to take your job at $20,000. That might just be a good age discrimination case. And by the way, this is happening across America today. I feel sorry for everybody in their 50s because the men and women who are 50 years old, they can cut because you're about ready to get retirement, get their pension, and that's where they are nailing you. But you know what they do if they're smart? They make it an economic decision. We're not firing you because of your age. It's an economic decision. Gender discrimination usually applies to women, can be applied to men. Can you prove, and this is what you got to have on a case like this, that you are a woman and you're working in a department with all men, and I've had cases against big corporations like this, and you're able to prove that only the men get the raises, only the men get the promotions. Good gender discrimination case. Race discrimination. You can always play the race card. I can tell you right now, if you are a black woman who's over 40 years old, you got some bullets in your gun. Race discrimination. A lawyer friend of mine recently settled a case against an international beverage company where I could not believe the facts of this case, where the N-word was written on walls and thrown around pervasively, and the blacks that worked in this company, I mean, when I read the facts of the case, I'm like, oh, you got to be kidding me. You would hope that doesn't happen anymore, but guess what? It does. Religious discrimination. I'm a Catholic. You know, we were once discriminated against. But you know what? The Boondock Saints took care of that. You all didn't think I'd work that in. The Boondock Saints took care of that, so everything's all right now. Go see the Boondock Saints movie. Retaliation. That's when they retaliate against you for doing something. You know, you take some type of action that you're lawfully allowed to do, and they retaliate against you for firing you. For example, you complain about sexual harassment, and then they fire you. You have a sexual harassment complaint and a retaliation claim. Workers' compensation. Don't ask me why. Ohio doesn't allow this, but Kentucky does. If you file a workers' compensation claim and you are fired after you file the workers' compensation claim, you can bring a lawsuit. There's a statute that forbids that you were fired because of a workers' comp claim. FMLA, Family Medical Leave Act. Complicated, you got to get a lawyer involved. And I'm just going to go ahead and say this on my videotape. A law that doesn't have a lot of teeth. Bottom line is, if you feel like you've been discriminated against because of a Family Medical Leave Act case, contact a lawyer. EEOC, the Equal Employment Opportunity Commission. The most famous head of this was Clarence Thomas. You may not know this, but Clarence Thomas, who sits on the Supreme Court, once ran the EEOC, and he did a fantastic, wonderful job. I always thought it was funny that he gets attacked by the far left when Clarence Thomas, a black man, ran the EEOC, and they actually dealt with more complaints than ever before. But anyway, here's what the Equal Employment Opportunity Commission is. It is a federal commission to where if you have a claim for a discriminatory case, gender, age, race, sex, whatever, if you file your claim with the EEOC can decide to investigate that claim for you, or they cannot investigate the claim. But what they do is you get what's called a right to sue letter, whether they investigate it or not. Be honest with you, I don't really care. I file an EEOC complaint because if you do so, you then can file a lawsuit in federal court. You want to be in federal court and not state court on an employment case. The bottom line is, file an EEOC complaint. That's the first thing we do for our clients. And then you get a 90-day letter. You have to do this usually within 180 days from discharge, 90 or the event. In the 90 days, you have to file a federal lawsuit, but it's called the EEOC. Also, after you file an EEOC complaint, sometimes you can mediate it. They will help you try to get your case settled. If it doesn't work, the good old lawsuit. A lawsuit is a powerful weapon, and after you go to the EEOC, you file your lawsuit. Whistleblower. This is everybody thinks they got dirt on their boss. Oh, I got dirt on the boss. I want to be a whistleblower. This is a very, very finite situation. First of all, your employer, you must give them an opportunity to correct it. If you know your employer is ripping off the government, you have, like GE, you have to give them the opportunity to solve the problem. You have to do that. I apologize. I wanted to get through this video before I took a drink, but I can't. Government. It has to be a government employer that they're ripping off the government. That's where you get a whistleblower case. In other words, if you work for Jim's Lawn Care and he doesn't have government contracts, you don't have a whistleblower case, even if you have dirt. Your damages. What are you entitled to in an employment case? Medical bills, if it's so severe you needed medical treatment. Lost income, which could be massive. I'm currently representing somebody, and we're getting ready to file a lawsuit today. This woman was making $95,000 a year as an executive assistant to a large tri-state employer. In this economy, do you think she can fight another $95,000 executive assistant job? No. Huge lost income. Humiliation. Again, not usually in gender and age discrimination cases, but in sexual harassment cases. Also, we file these claims. You are entitled under the law to get attorney fees. So the attorney is going to fight like hell for you, just like we will fight like hell for you, because a lot of these times you can get attorney fees. Corporation. A corporation is always going to be sued with the individual, for example, that's caused it. So let's say you're getting sexual harassed by your supervisor. The corporation that he works for and that individual are going to be named as a defendant. You're going to want to get your employment file. This is a huge piece of evidence. I can tell you right now, before we take a claim to the EOC, I'm shocked that employers, they will not release your employment file even with a release. But what's your employment file is very important. For example, out of the blue, you get fired because you're doing a lousy job, but in your employment file, year after year, you have outstanding reviews. Lots of evidence in an employment file. Settlement. Just like in any case, you can settle a claim from the beginning to the end at any time. Mediation. Again, you try to mediate. That case that I just told you about, we tried to mediate. Didn't work out. We'll file the lawsuit today. Trial, same as any trial. In these cases, in federal court and state court, you don't have to have 100% of the jurors find in your favor. And by the way, sometimes these cases are tried before a judge. The appeal process, one of the reasons why you want to try to settle your case, the appeal process takes years. Contingency fee. Most of these cases, like we do, we take on a contingency fee, which means for 33%, we become your warrior. You don't have to write a big check for $5 and $10 and $20 and $50,000 of money you don't have. Public opinion. I can tell you right now, when you try a case involving discrimination by an employer, do you know who's sitting on the jury? A bunch of other workers, not employers. Public opinion is very much on the side of an employee. If you are wrongfully harassed and discriminated against, the public opinion, and also from jury, is very sympathetic to you because they see themselves, their spouses, their relatives, and friends in the same shoe that you're in. However, if it's a baseless case, they're just not going to sock it to an employer, for no reason because they're a big, bad employer. Because people in this day and age also respect all the problems and issues that a company has. So public opinion, I still think, favors the employee on good cases. On a bad case, it's not like, well, it's a bad case, but nobody's going to like that big, bad employer. Don't be so sure about it because that big, bad employer employs a lot of people in the community. And good for them for doing it. So there you have it. That's an overview, and it's just an overview of employment cases. I can't stress this enough. While you're still working and you're developing problems, contact us. They don't even have to know you've got us on your team. How awesome is it that while you're going through a serious, important issue at your work, you've got a lawyer guiding you and helping you make the right decisions, and they have no idea. We can tell you, yes, tape that meeting you're going to have with that supervisor. No, don't quit yet. Let us guide you. And let me tell you something. If an employer mistreats you and you have a good discrimination claim or sexual harassment claim, call us. We'll drop the hammer on them. Also, remember, you can email me at eric@ericdeters.com or text me or call me at 859-250-2527, the number and the email address at the bottom of the screen. I live with this BlackBerry. Why I'm doing these videos? It's right here because I'm checking it between breaks. But I will respond to you. Now, most employment matters aren't necessarily urgent, but sometimes they are. Let me tell you what's going on sometimes. They're getting ready to give you the option. You either quit and sign this release, or we're going to fire you. And they give you a day or two to do it. You're going to need to get a hold of somebody right away. I promise you that you're going to hear back from me right away and in time. Leave that message, Bulldog. They want me to sign something or they're going to fire me. What should I do? We promise to get back to you and give you some free legal advice. And if you have a good case, make sure you call me. As I always say, every dog has their day. I hope tomorrow is yours.